It is the voice of Indiana County, WCCS, AM 1160 and 101.1 FM, and it's time for another installment of Marshall Law. And since my disclaimer has mysteriously disappeared, and we have an attorney working on that right now, Marshall will simply tell folks that this should not constitute legal advice because the laws are different in just different jurisdictions. They may not apply to your case, or they may. You need to talk to a competent attorney who can help you with the specifics of your legal case. And that could be someone such as Marshall Chriswell. Good morning.
Good morning.
Hey, we've heard in various different settings the idea of civil lawsuits and civil filings. Brennan is out there talking about a civil filing. You think of cases where victims of crimes don't get satisfaction in the criminal courts but can still pursue a civil case against someone. Could you take us through that whole civil system and how it works in Pennsylvania? Because I know it's different in different states, but Pennsylvania has its own system, does it not?
Yeah, it does. And so when we're talking about civil cases for monetary damages, for money damages, and this could be anything from a tort case, which is something like a car accident or a slip and fall or a dog bite, or even a more business transaction where someone maybe owes you money, has signed a promissory note, or has promised to repay you and hasn't paid you back, or a breach of contract between businesses or between a consumer and a business, such as a home improvement contractor or any other type of contractual dispute. All of those are considered civil cases, and depending on how much you're seeking as far as monetary damages, you have options as to how to file those in Pennsylvania. So if you have a case that where you're seeking less than or up to $12,000, you have the option to either file in magisterial district court, which for these cases acts as kind of a small claims court. Okay. If it's up to $50,000 in Indiana County, it's different for every county. You have the option to file in the Court of Common Pleas for an arbitration, which is not a full-blown sit on the regular civil docket. It's not a full-blown trial. But it's an arbitration where you'd have a hearing before a panel of three attorneys serving as arbitrators or serving as judges. And then if your case is more than the arbitrational limit for the county, then you have the option to file at any of the three. You can file at magisterial district court, you could file it for an arbitration, or you can ask the court for a jury trial or a bench trial before a judge. So it's there are many different options.
And therefore, there are many different things to consider, and you need somebody with the legal mind and the expertise to determine which would be your best course of action in any case.
Absolutely. And, sometimes for those smaller cases, less than $12,000, sometimes it really makes sense to file a case at the magistrate. Those proceedings are more informal than at the Court of Common Pleas, and sometimes that really works to your advantage. If you don't have an attorney and you're filing a case, the magistrate level can be a place that's a little more comfortable than a large courtroom setting. But even if you do have an attorney, I file a lot of cases in magisterial district courts just because, listen, we can get in there, we can get a judgment. I don't have to go through a long discovery process. There's not a lot of procedure leading up to the hearing, so it doesn't cost the client a lot of money. And if I think that hearing is going to be, if we're going to be able to present our case adequately at the magistrate, yeah, we'll certainly do that. But there are also some cases, small cases, $10,000 that make more sense to file and request an arbitration.
I assume that when you're talking about going before the magisterial district courts, that you are bound by the municipality, the jurisdiction of each of those courts. So if a case happens in Indiana Borough, White Township, you automatically have to take it to District Judge Guy Haberl as opposed to the Clymer District and Judge Welch's coverage area, Judge Riga, and Judge Steffi as well.
That's correct. In different cases, we'll have different venues, but generally where the where the incidents that gave rise to that case occurred, that's where your venue is going to be, and that's where you'll have to file. So, absolutely, if it's within the jurisdiction of Justice Habrel or Justice Welch or Justice Rega, that's where you've got to file. Yeah.
I'm also assuming that it requires a lot of research on the attorney's part to determine, okay, do I want to do this at the magisterial district court level, or do I want to take it before the arbitration panel? What are some of the factors that must be considered then?
It is one. It's an issue of cost. Okay, I think that's first and foremost what we're looking at with these small cases, because and I mean $12,000 is nothing to sneeze at, of course, but whenever you're talking about the costs of preparing the pleadings. And engaging in discovery, sending interrogatories and requests for production of documents to the opposing parties, and getting those back and reviewing them and fighting over whether they provided you everything that they were supposed to provide. When you take all of those costs into consideration, that's the biggest thing. Is all right, because at the magisterial district level, you don't have any of that. There's no discovery. There's no the pleadings are a pretty simple form. The magistrate requires a particular form. That cuts costs, but it also limits your ability, or my ability as the attorney, to obtain evidence and understand what the case is all about from the other side.
So the complexity of the case is really going to play a major role there.
Sure. And sometimes I say, well, this is a $10,000 case, but it would require so much work to be able to prove it up that it doesn't make sense. We can't take it to the magistrate because there's no way we could probably win, because we can't prove our case without evidence that we don't have. And then, but does it make sense to go to an arbitration panel whenever we have to go through that entire process, and you're going to spend that much to try to recover it? So, complexity and cost are really the biggest factors.
Talk about, if you would, you began the segment actually discussing tort cases and cases involving accidents, personal injury, and those sorts of things. The preparation for those cases, because we see the TV commercials and we hear the battles. I take this percent, you take that percent, and all of that. It really isn't about that, though, is it? It's really about the case itself and the people who are involved. Talk about how the system works on behalf of those people who are injured.
Yeah, well, those a tort case is a case for where you're seeking money damages for injury to person or property. At its most basic level, that's what it is. That's the way our system compensates for obviously expenses, medical expenses, and property damage expenses and things like that, but also for pain and suffering and future lost wages and all those kinds of things. So that's the system we have, and those kinds of cases are considered civil litigation, civil cases, and those are filed, as we've talked about today, in either in a magisterial district court, in court of common pleas, where it's going to be heard before an arbitration panel, or on the regular civil docket, where you either get a trial judge or you can request a jury trial. And those cases are some of the most difficult cases in a lot of different ways, but they go along the regular civil system like everything else.
You have said in the past that for the vast majority of cases that come before a civil court, and particularly I would assume in these cases, the tort cases, they're going to settle out of court. There's going to be some agreement reached between the attorneys for both sides. And is that still the case? And is that what we're talking about here? Yeah,
and that's true for most civil cases, whether it be a car accident or anything else. Is that eventually the case? There's 9 out of 10 cases probably are going to settle at some point before you reach trial. Now you never know which of those 10 cases is is going to go to trial. And so it's really important that if, when you hire an attorney for any kind of a civil case, that the client understand and that the attorney be someone who is going to work the case very diligently, because the settlement, it's not like, all right, well, I've got this new client and there was a car accident and there were this much in property damage and this much in medical damage and medical bills and things, and okay, this is the number we automatically settle at. All right, that's not the way it works. It's, you've got to really work diligently to prove the case and be fighting and negotiating the entire time to get the best deal. And I think sometimes there's a perception that settlements are almost automatic, and that's just not the case.
Really seems as if this is one of those cases where you need to get to an attorney if you have any idea that you might have a case that you would like to pursue, and there's a lot of groundwork that has to be done.
Yeah, that's right. And you don't want to wait. All these cases have different statutes of limitations, and so you always want to be cognizant of the fact that there is there are deadlines, and these deadlines they're not in most cases they're not flexible. If you don't, for instance, a lot of tort cases have a 2-year statute of limitations. If you know that you've got that kind of a deadline, you don't want to wait until a month before and get to an attorney and say, hey, we've got to file something. You need some time for preparation there, and you really. You got to be cognizant of those deadlines, and you want to talk to somebody right away, because the deadlines are all different. There's some cases that are a 2-year deadline. There are other cases that have a 4-year statute of limitations, and there are different ones as well. So yeah, that's something you really got to be careful with.
And you're not walking this road alone. You need the attorney. That's going to be the guiding light through this whole thing
from the beginning. And I think I've said on this show before, there are so many times that someone comes in and says, well, I've got a case that I filed, and it's been going for about a year, and I've been, and we've had all these different things happen, whether it be hearings or rulings or discovery motions and they bring in a stack or grocery bag full of documents, and I say, wow, this is going to cost you twice as much for me to just catch up and try to get this case back on the right track. So that's you really want to have somebody involved from the beginning.
Do-it-yourself lawsuit's not the best idea.
Yeah.
So to get in touch with you, what do they need to do?
You can stop into the Atrium Building in downtown Indiana. Call me at 724-465-5826 or go online to westernpalawyer.com.
He is attorney Marshall Chriswell, joins us every other Monday, although we're doing 3 weeks in a row because you had some times where you couldn't come in over this summer, so you'll be back next Monday.
That's right. Looking forward to it.
Very good.